If you're like me, your head is probably full of questions. So let's take some questions from our studio audience. It's a small audience. We had more when we started, but halfway through, a lot of them just cut out. I guess they got bored. But those that are left haven't moved. They've been glued to their seats. And okay, it really wasn't that funny. Who better to ask hypothetical questions than a hypothetical audience? The first involves avoiding trust. If my clients agree in writing, can I avoid the need for a trust account and put their money elsewhere? In theory, this is possible. In practice, if you want to stay in practice, this might not be the best approach for you or for your clients. The rules of professional conduct seem to allow for it. If the client gives informed consent confirmed in writing to a different arrangement, Rule 1.15c lets you deposit these funds directly into your operating account instead. But it's not as easy as it sounds. The two key words here are informed consent. To get your clients informed consent, you must provide enough information so they'll appreciate the risks involved. At the very least, your retainer agreement should emphasize that putting funds into the operating account doesn't affect your duty to refund unearned fees, that funds held elsewhere are subject to greater risk. It's harder to get a refund if something goes wrong. And in your retainer agreement, you might suggest the client have an opportunity to consult with other counsel before signing off on a different arrangement. Unlike a trust account, the liquidity of a regular account depends on the stability of the lawyer that owns it. What could possibly go wrong? Bankruptcy. If you declare bankruptcy, a trustee may freeze these assets and prevent you from issuing a refund. Seizure of assets. If your assets are seized by law enforcement, other creditors, or taxing authorities, say the IRS slaps a lien on your money, there goes your client's money as well. Misuse. When client money is mixed with your own, it's much easier to make a mistake and use the funds for other purposes. That's why we frown on commingling. Of course, the worst thing, the one thing that could possibly go wrong, and eventually will for all of us, is death. If you die before fees are earned, funds within an account bearing your name will become part of your estate. A probate court will have control over the funds. By contrast, since funds placed in a trust account aren't your money, clients can get their money back without these complications. If you were the client, would you sign an agreement to place your funds in greater jeopardy? In most cases, it's hard to see how clients would benefit from such arrangements. But a desire to avoid the chore of trust accounting won't justify a departure from practices designed to protect their interests. In short, we may not reduce our professional risk by increasing our clients' financial risk. If you're the only person who would benefit from a proposal that places client funds at greater risk, expect the Attorney Grievance Commission and courts to question the validity of your client's consent. Under a judicial microscope, it's easy to find fault with the language of the agreement or the details disclosed. If the client wasn't sufficiently informed about the risks, lawyers seeking to circumvent trust account rules may be sanctioned for violating them. So don't put too much faith in rules allowing for informed consent. When you place client funds at greater risk, you place your license at risk as well. Engagement fees. My retainer requires a $1,000 engagement fee that's non-refundable and earned upon receipt to assure that I won't represent the other side. Must I put it into trust? The practice probably started with small-town divorce cases. Take a husband who consults with the 3 best divorce lawyers in town just to preclude the wife from retaining anybody of quality. It made sense in that context for each of these lawyers to charge a fee for passing up the other client. Obviously, if they consult with the husband and the husband declines to retain them, they don't have the ability to jump over to the wife's side. In that context, an engagement fee made sense. So the rules don't prohibit you from charging an availability fee to foreclose you from representing an adverse party. And you can put that money right into your operating account as it's earned by your availability alone. The problem is that many of us tack on what we call an engagement fee whenever we're retained to do anything, as compensation just for agreeing to take the case. If the client later complains that you took her money and did nothing in return for it, be prepared to justify the fee. Courts rarely hold fees as non-refundable or earned upon receipt. That kind of language in a retainer agreement will often be a red flag. Now, if it's truly an engagement fee, it can be earned after your consultation because basically you are boxed out of representing anybody else. The only person you could represent in that case would be husband. But remember, this is not something that just allows you to profit right off at the top of every case. Absent the situation we're discussing, I'd be very careful about using it. In the dictionary, earned and effort always come before fees. When in doubt, follow the alphabet and Rule 1.5, put it in trust, put in the effort, and take your earned fee. Flat fees. I handle criminal cases for one flat fee start to finish. When must I put the fee in trust, and when can I take payments along the way? The answer should be clearly stated in your retainer agreement. The problem is that many criminal lawyers, I've seen this a lot, they'll charge a flat fee of $30,000 to defend a felony drug case. And it's a case that can drag on for more than 2 years. Well, 6 months and 60 hours of work later, the lawyer says, I've done at least $10,000 worth of work. Heck, 60 hours at $200 an hour would be $12,000 alone. So the lawyer feels justified in taking $10,000 at that point. After all, she's earned it. But that's not what the fee agreement says. A fee agreement that charges a flat fee for defending a felony case doesn't have any milestones to specify when partial fees are earned. This isn't an hourly rate case, so you can't just take the value of your time and guesstimate how much you've earned. It's got to be spelled out in the agreement. In this instance, you're going to need to wait until the entire case is over. Also, what happens if you're discharged in the interim? Does your retainer agreement provide for that? It's not just as easy as saying, I'll take $30,000 and I'll defend you. You have to think it through. These are problems that you can prevent with a well-drafted retainer agreement that breaks it down. Break that case down into stages. Use those stages as milestones for payment so that you don't have to wait until the end of the entire case to get paid and ruin your cash flow. Make sure the amount you're charging, whatever the percentage or dollar amount might be, is reasonable by the triggering event that allows you to take partial payment. And be very clear about it. For example, in a criminal case, a part of the fee may be allocated to appearing at the arraignment, at bond hearings, or preliminary hearings. You may anticipate more work on discovery or pretrial motions, and even more by the time of trial. If you think it through and anticipate the amount of work that may be involved at each stage within the life cycle of a case, your flat fee agreement can provide for progress payments along the way. So take your time, think it through. This is going to ensure that no one can dispute the fees that you've taken because they're spelled out and they're reasonable and they're clear. And most importantly, they're all in writing. Preventing overdrafts. Since banks are reporting overdrafts to Bar Council, can I keep extra funds in trust to avoid bouncing a check? That's a really good question. You never want to bounce a check, certainly not a trust check. The bank will automatically send an overdraft notice to Bar Council, triggering an audit of your account. Under Rule 1.15a, You have to hold property of clients or third persons separate from your own money. Otherwise, you're commingling. But there are exceptions. Account fees, service charges, minimum balance requirements. Those are spelled out in the rule as instances in which you can leave some of your own money in the account. But I will tell you, as a practical matter, most banks waive account fees, service charges, and minimum balance requirements in trust accounts. How about as a cushion to stay out of trouble? That's not in the rule. So you may not deposit your own money into the trust account to keep checks from bouncing. Some lawyers try to accomplish the same thing by leaving fees in the trust account long after they've been earned. For example, you settle a personal injury case for $300,000. The lawyer might leave his $100,000 contingency fee in the account long after dispersing the balance of the recovery to the client and paying off the lien holders and other expenses. Some lawyers will even draw these funds down over an extended period so that their trust accounts reflect higher balances than needed to cover other transactions. But this is just as bad as depositing your own funds into the account directly. It's called commingling. It's the same as if you were to take a check, write it to your trust account, and deposit it in your trust account. Whether you're putting your own money into trust or leaving earned money in trust, it's still your money mixed in with your client's money. That's commingling. So once again, once you've earned the fee, take your money. Preventing overdrafts is a matter of properly managing your trust account. You cannot use the expedient of simply leaving your own money in there so that you don't bounce a check. Credit cards and payment apps. This is something that's become more important in many practices, particularly with the pandemic. Our audience member asks, nowadays, I can't take payments in person, but may let clients use apps like PayPal and Venmo to pay fees and retainers online. Are such payments allowed? Using these apps to pay fees that you've already earned doesn't trouble me, but taking retainers through PayPal, Venmo, or ordinary credit cards does trouble me. Again, we come down to the difference between services rendered and payments on future work. When you're getting paid for services you've already rendered, that's your money anyway. That goes into your operating account. We don't have to worry about complying with IALTA or the trust provisions because they're never going to hit the trust account anyway. So if a credit card processing company or a payment app were to take a processing fee out of the funds that hit your operating account, that's perfectly fine, perfectly ethical. The problem deals with future work. Rather than place unearned fees into your attorney trust account, services like PayPal take a small percentage to cover processing. Regular credit card companies do the same thing. With PayPal, the money actually goes into a PayPal account, and you have to then transfer it into trust. This isn't any different than placing unearned fees directly into a personal bank account. You're bypassing regulations designed to protect client deposits. You're commingling your own funds with those you have yet to earn. The rules require you to protect client funds by putting them into trust. The PayPal account is not a trust account. The only place a client's money can go is to the trust account. There's no exception for PayPal, Venmo, or any other online service, nor is there any grace period provided for those who would later transfer those funds directly into their trust account. Once funds are placed in your name and not in an attorney trust account, you're breaching your duty to safeguard client funds. So if the funds hit your PayPal account and you get hit by a bus tomorrow, before you had a chance to transfer that into trust, suddenly all that money is part of your estate. You can see the complications that you have because you've actually not safeguarded the fees in a trust account. Even if you have funds deposited directly into the trust account, not all the funds are going to make it there. These services deduct processing fees from the client's payment, as well as fees for any rescinded transactions or chargebacks. These are business expenses which your firm should pay. You can't take them from client funds in your trust account. So PayPal is fine for paying fees that you've already earned, but don't trust it with retainers. Now, I've had many questions from people who swear by Venmo and certain other payment apps, and they will tell me they don't ever charge any fees. I don't even know how they make money, frankly, but they will put money directly into your trust account without taking out any fees. There is no separate account like PayPal and this sort of thing. The bottom line is this. When you're managing other people's money, do you want to try to jury rig a payment app that's not really designed for this application? Or do you want to use something that takes IALTA compliance into account? If it were me, and it has been me, I'm going to go and put my trust in IALTA compliant processors like LawPay or LexCharge. These are services that are designed for lawyers. They'll put 100% of your client's money into trust and take their processing fees from your operating account. This eliminates any commingling of funds, ensures that retainers go directly into escrow, and it prevents your clients from paying fees that should be borne by your firm. I know what you're thinking. Can I pass these charges on to my clients? Ethically, you can. Provide for it in the retainer agreement, and you can then nickel and dime your clients with these charges. But I don't think it's a particularly good business practice. People don't respond well to getting nickel and dime. I would consider it a cost of doing business, particularly today. We've had the pandemic when clients cannot come into your office and physically hand you a check, and even when they can, most millennials don't even know how to write a check. They may not even have a checkbook. It's a hassle for them. Everybody nowadays pays with plastic, and your firm needs to get with the times and take plastic, but take it in a responsible way. Sign up with an IALTA-compliant processor. If for some reason you don't feel you have enough business to justify the setup or maintenance fees for one of these services, then go ahead and use the payment apps for fees you've already earned, but don't trust them with your trust account. Phishing for lawyers. After demanding $90,000 on behalf of a supplier of silicone for electronics, I got a cashier's check for all of it. My client wants me to wire its recovery from my trust account to its Canadian bank. Any need to wait? This deal smells fishy. We as lawyers are prime targets of email scams. Scams designed to tap into our trust accounts. And here's how it generally works. You get an email from a foreign company seeking assistance in collecting payment from an American firm. Often this email is addressed to an unspecified attorney and lacks any indication of how the sender actually found you. The email requests a retainer agreement, which the client signs and returns right away. A short time later, the client informs the lawyer that the debtor has agreed to make a payment to avoid legal action and will be sending a check directly to you. Acknowledging your 1/3 contingency fee, the client requests that the remainder be wired immediately to a foreign account. You get what looks like a valid cashier's check, deposit the funds into your trust account, and after dispersing these proceeds, this fraudulent check is returned unpaid to your bank. Your happy client has disappeared with the wired funds, and you have probably overdrawn your trust account. Oh, and to add insult to injury, the bank will report any overdraft to bar counsel. This scam will not work if you manage your trust account properly, waiting for all funds to actually clear before drawing on them. The bank will let you draw on an available balance of money that has yet to be collected, but the rules of ethics don't. If lawyers didn't fall for these tricks, the spammers would stop phishing. Rather than take the bait, you must read all emails with a critical eye. Let's take a look at the emails that we actually received. On April 1st, we get an email from Kim Jong-oi of Silicon Seoul. Dear Attorney, we're a Korean firm that supplies metallurgical-grade silicone used in the production of electronics and photovoltaic cells around the world. And apparently they supplied Atlantic Sunergy with some silicone, and they are owed $90,000. So they want you to help collect. So what you do on April 1st is you send a retainer agreement or signature by Silicon Seoul. Only a couple of days later, on April 3rd, 2020, at 3:21 p.m., you get an email. Great news! Atlantic Sunergy has received your email and has agreed to pay the full $90,000. So you take your 1/3 fee, deposit the cashier's check that you're going to get, and wire the remaining $60,000 to us at the Royal Bank of Canada. And they have wiring instructions attached to the email. Like clockwork, you get a check for $90,000. It took very little work on your part, but you've earned that $30,000 fee. So you deposit the $90,000 into your trust account. And before the funds have even cleared, you oblige the client by wiring $60,000 to that Canadian bank account. The only problem is, it's a bogus check. So what you've done is wired $60,000 of someone else's money, or even overdrawn your account by $60,000, and suddenly you've got a problem. You have misappropriated trust funds. You have failed to properly manage your trust account. And you're out $60,000. You've been caught in a phishing scam. Rather than take the bait, you must read all emails with a critical eye. If you read carefully, you saw the following clues. While silicone is often used for breast implants, you wouldn't put this synthetic polymer into electronics or solar panels. Electronic chips are made from silicon. It may seem like a small detail, but a legitimate silicon supplier wouldn't get the spelling wrong in its own company name. And while Korea does manufacture the polymer, it imports silicon from Japan and elsewhere. A little bit of Googling will tell you all you need to know to spot the scam. Kim Jong-oi sent his emails on Wednesday, April 1st at 2:08 p.m. and on Friday, April 3rd at 3:21 p.m. Eastern Time. Why is this Korean business executive sending emails at 3:08 a.m. and at 4:21 a.m. Korean time? If Mr. Oi's company really is from Korea, why has he instructed you to wire funds to a Canadian bank? How often do you get great cases through unsolicited emails sent to undisclosed recipients? And why, of all the lawyers receiving this solicitation, did the client pick you? How often have you collected $90,000 immediately after sending an email demanding payment? If it's too good to be true, it probably is a scam. Even if you miss these telltale signs, this scam won't work if you're properly managing your IALTA account. Rather than wait for checks to clear, many banks will let you draw on an available balance, which includes the deposit of checks that have yet to clear. But when it comes to trust accounts, you can only disperse funds that have actually been collected by the bank. So no matter how desperate this client may be to get its money, you would have caught the scam just in time if you had waited for the funds to clear. Lawyers who have been caught in these phishing scams have been disciplined for IALTA violations by overdrawing their accounts, by failing to safeguard client funds, and if they really did take IALTA funds as their contingency fee, for commingling and misappropriation. If you do it right, this scam cannot work on you. The spammers wouldn't be phishing for you if certain lawyers didn't take the bait, and they get more and more sophisticated all of the time. But you can stop them if you manage your account properly. Recommended software: I'm one of those legal dinosaurs that still keeps handwritten ledgers. Are there specific programs I should use? Yes, and there are lots of excellent programs to choose from. Just run a search of legal practice management software, and you will find hundreds of reviews online. Some of these programs reside on your office computer system, others in the cloud, and most function on both for speed and security. The right one for you will depend on the size of your law firm, the nature of your practice, the overall cost of implementing it, and a range of personal preferences, maybe even some of the preferences of your IT consultant who may be assisting you with support and implementation of the program. There are two basic types of software you're going to want to look at. One is billing and accounting software, and the other case or practice management software. Some of the more popular programs actually do both. They can help you with billing, bookkeeping, but also in managing cases and your time and your communications and the like. Let's first talk about billing and accounting software. These programs help you keep track of your time and expenses, issue bills, manage your trust and operating accounts. Many include components that will process your payroll as well. There are programs especially designed for law firms like PC Law and Time Slips, but many firms have customized QuickBooks to meet their needs. I use PC Law. It's a program I've been using for over 20 years. It prints our checks, prints out the bills, keeps track of all financial transactions at our firm, and can generate ledgers and reports on all aspects of our operation. There may be better programs out there now, but of course I stick with what works for me. If I were adopting a new system, I would review what's out there now. There weren't as many programs on the market when I created my firm back in the 1990s. Let me also give an honorable mention to a program called Nota. This is a product of M&T Bank to assist law firms who maintain their trust accounts there. I've actually seen a demo of the program, and I'm quite impressed with some of the online trust banking features that they provide their depositors. It's not going to replace the need for your own software, but it is an excellent tool nonetheless and can really help you in keeping track of your trust account. Practice management programs include software like Clio, MyCase, Abacus Next, Amicus, Practice Panther. These are programs that can really simplify your life, helping you keep track of your cases, communications, document assembly, and many have components to handle accounting needs as well. I happen to use Amicus, which is also a program that I started with over 20 years ago. But there's a lot more on the market today. You'll also want to tweak the programs to practice the way you do, perhaps loading your templates so that they can assist with document assembly. No matter what you pick, you need to be prepared to invest time and money into its implementation. There is a learning curve, but within a very short time, I promise you that this investment is going to save you enormous time, enhance the efficiency of your practice, help prevent things from falling through the cracks that can lead to problems, and increase your bottom line. It's going to minimize the amount of support staff you need to hire, or, at least in my case, it's allowed my support staff to do things that go well beyond some of the rote tasks that are taken care of by the software. So the investment of time, the investment of money, has been well worth it because it's saved us time, it's saved us money, it's increased our profitability, it's increased the quality of life for everybody that works at our firm. I can't speak more highly of the need to invest and get with the program, with the right program, to assist in practice management. Billing for billing. Whenever my client gets a bill, he calls to question each of my time entries, keeping me on the phone for 30 to 45 minutes each time. May I bill him for this time? Billing for billing questions is as close as you can come to inviting grievances. Like it or not, Our clients have every right to question the charges contained on their bills. You have to distinguish, though, true billing questions from questions about the case itself. If they're questioning your strategy and you're now trying to educate them as to why certain things were or were not done, things that are going to be required in the future and the like, then some of that may be billable. But you don't want to antagonize an already tense situation over billing by billing your time for that on the next bill. Before you call back, review the bill yourself. I'm sure you've already reviewed a pre-bill to ensure that the charges were accurate, but you would be wise to refresh your memory of the matter and try to determine what the client's issue may be before calling him back. The client will expect you to be fully familiar with the case, and it's very important that you show a firm grasp of the details so you make a good impression on the call. Return the call promptly. You may be dreading the conversation, but procrastinating will only make matters worse. Clients hate it when their lawyers fail to return their calls, and if they're already brooding over their bills, delays will only add to the tension. Stay professional. You may want to defend your bill, but don't be defensive or combative during the call. Your primary job is to listen carefully. Let the client express all concerns. Quite often, billing questions mask deeper concerns about the future of the case or fears about mounting costs as matters progress. This is particularly true of clients who haven't had the need to engage lawyers before. Even if you quoted a healthy retainer and discussed anticipated costs at the outset of the case, getting a bill brings new reality to the situation and may trigger old fears. Focus on client service. Don't regard billing questions as intrusions. Fielding these questions is a part of your job. I wouldn't bill for it, but part of the value that you provide is to help the client understand the costs and benefits of legal action. Show value. Billing questions give us an opportunity to display our professionalism, to explain the strategic decisions underlying the tasks that are recorded on the bill, and to show our value as attorneys. If you bill correctly, the invoice itself should show that value and hopefully preempt many questions. In my office, I have a rule that I call the spilled ink rule. Invoices must show our effort. So the more time we bill on a task, the more ink we need to spill in describing it on the client's bill. A few words might be sufficient for a task that only took 1/10 of an hour, but that won't cut it as the clock continues to tick. When your clients get your bill, they shouldn't have to wonder what you did and why it took so long. They should see the effort. But if they still don't get it, use billing questions as a chance to reinforce your value, to reassure clients that they retained the right lawyer. Client refunds. After ordering numerous revisions to his will, my client changed his mind yet again, claimed that my latest draft misstated his wishes, and demanded a full refund. If I give in, can my refund be used against me? Some clients have a way of turning on us. Quite often, it's the client that praises you effusively at the beginning, telling you what a talented and honest lawyer you are. But as things progress, seeds of distrust tend to grow, and you become a serial liar and a truly terrible person. Forgetting about your loyal service, that client wants a full refund. Is it worth the fight? You need to ask yourself some questions. Does he have a point? Demanding his money back may be unreasonable, but the client won't be the focus of a grievance. You will. How would an audit of your file look to bar counsel? Can you show the work product designed to justify your fees? Did you bill consistently? Some of us are so busy doing our jobs that we forget to bill for it. And this can cause sticker shock and place great strain on an attorney-client relationship. But it's also an ethical issue. It's a failure to keep the client informed of your progress on the case. The rules require that you communicate effectively and frequently. A failure to bill on a regular basis breaks that rule. Did you respond promptly to client questions? Did you ignore requests for a bill? Or did you forget to do a retainer agreement at all? Did you make any mistakes during the representation? Could bar counsel question your competence, your diligence? Did you fight with the client over fees and other issues? Did you engage in nasty emails back and forth or intemperate conversations? These are things that can come back to bite you in a very big way. Are you ready for a grievance? It's hard to part with fees that you've worked hard to earn, but it's also very difficult to deal with grievances and potential misconduct charges. Consider the amount of the refund, but also consider the time and expense of defending your license and the extreme anxiety that you're going to have to live with until it's resolved. Obviously, if you put in $100,000 worth of work and the client wants a refund, it might not even be possible financially for you to accommodate the client's needs. But oftentimes I'm seeing grievances over $1,000, $500, $1,500. The key question here is whether it's truly worth it. Just remember, you can't preclude the client from filing a grievance or have the client sign a waiver of such rights. But as a practical matter, refunds really do reduce a disgruntled client's motivation to hurt you. It may even be a good idea to do this after a grievance has already been filed, but make sure that you consult with your ethics counsel should that situation arise. As long as you do it the right way and for the right reasons, issuing a refund shouldn't hurt you. Ultimately, are you better off giving his money back and focusing on clients that truly appreciate your work? If so, give the money back and let karma do the rest. You'd rather be spending your time on clients that really need your help and really appreciate the efforts that you're putting forth on their behalf. Avoiding retainers entirely. Here's an interesting question. Can't I avoid this whole problem by billing for my work after it's completed? If I don't take retainers, I won't need a trust account at all. But in reality, you would be trading one problem for a more significant problem. You might not need a trust account, at least if you don't take retainers and you aren't taking third-party funds, settling an auto tort case, for example, where you have to put the gross settlement proceeds into trust and then draw off of that. If you don't have that kind of a practice, I suppose you could always bill clients after the work has already been done so that the money can go directly into your operating account. And yes, you wouldn't need a trust account at all, but you'll have an account receivable problem. You are going to have clients who get sticker shock once they receive a bill from you and may refuse to pay all or part of it. Maybe they don't have the funds when the bill comes due. Retainers keep the attorney-client relationship in alignment, managing client expectations and setting things straight so you and your client can continue to smile as matters progress. Retainers are an excellent way of not only ensuring that you get paid, but it's also an excellent client management device. A lot of times a client will say, it's the principle of the thing. I want to sue. I need to collect this. And they don't appreciate the true expense of litigation. Wouldn't you rather have that dollars and cents discussion up front? And why not punctuate it by requesting a retainer sufficient to do the job? Actions speak louder than words. Rather than postpone a tense discussion over litigation expense, if your fee agreement requires a substantial financial commitment up front, then the client has understanding that if he or she wants to invest in that litigation, the client's going to have to invest in that litigation up front. Why should you take 100% of the risk and risk never getting paid at all? Requesting retainers, taking those funds into trust, is not just a way of securing your fee. It's a way of bringing the client to a true dollars and cents decision that will impact the course of the case and whether the client truly wants to pursue it. If the client doesn't have to pay any money up front, a lot of times the client will say, sure, go for it, not really appreciating the financial commitment that will be required. If you require that financial commitment up front, you may find a client who no longer thinks it's about the principle of the thing, but about principal and interest. Retainers work, and all you need to do to take them is to manage your trust account properly. Don't forego that device simply because you don't think you're capable of balancing your trust checkbook. Which leads us to the question of the hour: your money or your license? If you manage your practice the right way, you'll never have to choose between the two. I'm Erwin Kramer. I look forward to meeting each of you in person when circumstances allow, and in the meantime, wish you a profitable and truly rewarding practice.